So it looks like we've hit 7 o'clock. So I was going to get started. And if people join after, that's fine as well. Nice to see all of you here this evening for open meeting law training. My name is Janelle Austin, and I'm one of the attorneys that works with the town and advise communities across the state on open meeting law issues. A couple of sort of housekeeping measures before we get started. As you all know from when you logged in, this meeting is being recorded, so please keep that in mind with respect to questions or comments along the way. And I'm obligated to announce that, as you all know, and we'll get into that for open meeting law purposes, but you all are being recorded this evening. The purpose of the training tonight is really to provide a forum to go over best practices, sort of the fundamentals of the open meeting law. I know many of you here tonight are pros on all of that. It's always good to do a refresher. We always are receiving additional determinations from the Attorney General's office, additional guidance, and obviously there have been some changes over the past couple years that we'll go over, including some additional new cases. So this is really to provide an overview and really best practices. We're not going to go into any specifics that any of you have dealt with, either as employees of the town or volunteer elected board members or commission members or public body members. Certainly, if there are any specific questions, always happy to answer those, and you can reach out to Dennis or Beth and we can connect on that. But given that this is a public forum, we're really just, the goal is to provide an overview of best practices. I would ask if everyone could stay on mute during the presentation. That certainly helps. If people do have questions that they can and ask them, you can raise your hand or you can interrupt me, that's fine. The goal here is to be able to provide information to all of you in order for you to all to do your jobs. But feel free to raise your hand. I'll do my best to monitor it. And Beth is always good about looking out, if you wouldn't mind, Beth, for any questions that come up. And certainly feel free to jump in and just say, Janelle, I have a question about that. And I'll certainly leave some time at the end as well to make sure everyone's questions are answered. So we're going to get started here. I think everyone can see my screen. If there's any issues, just let me know. And this will be made available, both the training materials as well as the recording afterwards. It's a lot of material to cover. And so we want to make sure that everyone has all the information that they need. Any questions or technical issues before we get started? Okay. I'm going to just go ahead and mute for anyone that isn't. So here's just our disclaimer that we talked about before. The other thing I would mention is for all of you that do serve on public bodies, because this meeting is a training, we want to make sure that there's no deliberation on anything that is pending before your particular public body. So again, this is really a training and a chance to provide an overview of the open meeting law. So I always like to start with a little bit of a framework. The sunshine laws, the open meeting law is part of a sunshine law, which is a type of law that promotes transparency in government operations. So we know that we have the open meeting law that we're going to focus on tonight. There's the public records law and the conflict of interest law as well. And those are laws, or sunshine laws, or transparency laws that are really throughout the entire country, both at the state and federal levels. So it's really something that we deal with quite often, and certainly all of you are familiar with as well. The purpose of the laws is to eliminate secrecy surrounding what government does, what records are sent, what records are received, how are decisions being made on particular public policy projects. And so the general principle, and you'll probably hear this from me a lot this evening, is that under the open meeting law, members of public bodies can only conduct their business through an open public meeting unless there's a reason to go into executive session. So that is the guiding principle of the open meeting law. The government business has to take place that members of the public can see what transpires. And we'll talk about the specifics of that tonight. The open meeting law regulates the process which public meetings can be held and conducted. And it's a state law that is enforced by the Attorney General's office at the state level, but every public body in the town is subject to the open meeting law. So there's different areas that we're going to focus on tonight. What types of meetings are subject to the law? What rules need to be followed to hold a meeting? And what are some common violations and why? And this isn't a chance to make anyone nervous or concerned. It's really, I find when I do these trainings, and I've done them for a long, long time, the more you hear about open meeting law issues or hear about open meeting law practices and best practices, the easier it is for all of you to do the work that you do on behalf of the town. So the open meeting law covers essentially 4 major topics or legal requirements that we're going to review tonight. The first is notice. We know that a meeting has to be posted no later than 48 weekday hours prior. We know that the location has to be in an accessible location, and it must be posted in a place that is accessible 24 hours a day to members of the public. So members of the public have to know that the meeting is taking place and that it's going to be in an ADA accessible location, including a virtual or remote meeting. And we know that the meeting notice or the meeting agenda has to have a detailed subject of the topics that are going to be reviewed at that particular session. And we'll talk about that in a couple of slides. The nature of the meeting. What the open meeting law has is a presumption that public bodies will meet in open session, not executive or secret session. And that, again, goes back to the Sunshine Law that members of the public are entitled to see how government decisions are being made. There are certain reasons for closed sessions, and those are subject to certain different procedures, and we'll go over that. The conduct of the meeting. We know that there's, for all of our land use members here this evening, there's a difference between a meeting and a hearing. That also pertains, obviously, in the licensing context as well. And we're going to talk a little bit tonight again about who gets to speak and when, and remote and hybrid meetings. As you may all know, the governor extended the open meeting law remote option until 2025. So we'll go over that a little bit as well. And I always think about this timeline in terms of chronology. The meeting's posted, how is it posted, what type of meeting is it going to be, what takes place at the meeting, and then the minutes of the meeting, which come at the end. So the meeting minutes have to have detail in them. We need members of the public to be able to pick the meeting minutes once they're approved up and know essentially what took place at the meeting. I always use the example, if I'm sitting at home and I just moved to town and I'm like, do I want to attend this particular meeting? Do I want to go to the planning board's meeting, ZBA meeting? I'm going to pick it up and say, this is what topics are currently being reviewed. This is what the board decided to vote on at the time. We're going to talk a little bit about the approval process. It has to be within 3 meetings or 30 days, whichever is later. So that's going to differ based on how often a particular public body meets. And we're going to talk about the approval and how that is done, both internally and also posting later for members of the public to see. So a quick summary here in terms of meetings. All meetings of a public body must be posted not less than 48 weekday hours prior to the date of the meeting. And it has to list all of the topics that are going to be discussed, including executive sessions. So keep in mind around the holidays, between Thanksgiving and New Year's, obviously that time frame may vary based on particular holidays that are recognized. And so you always want to make sure it doesn't include holidays or weekends. Regardless of whether a meeting was posted, a meeting occurs when a quorum of the public body discusses matters within its jurisdiction. And we're going to talk a lot about what is deliberation and what the Attorney General has deemed to be an improper deliberation, and we'll go through that. So the quorum can be reached simultaneously. So if an individual sends an email to the entire board, or serially, so one member sends it to another person who sends it to another person, that would trigger the open meeting law and may run afoul of the legal principles that are set forth. We'll go through that. We often receive a lot of questions on subcommittees, so I always like to focus a little bit on what is a subcommittee and is a subcommittee subject to the open meeting law. That is something we've seen a significant uptick in both complaints and questions on across the state in the past couple of years. So just wanted to emphasize that a subcommittee is essentially a subgroup of the major committee that is working on a particular project. And so there's 3 factors that the Attorney General's Division of Open Government will look at that I've included here as to whether or not a subcommittee has been created. And that is whether or not the group is within government, empowered to act collectively, and serving a public purpose. So a classic example is if a public body creates a working group or a task force to advise it and votes to say, will these 3 members work on this particular project and report back to the public body, then a subcommittee is most likely created. So that would trigger then the subcommittee having to post meeting minutes or post a meeting agenda and prepare meeting minutes as well. So some practical ways, I always like to focus on the practical to avoid a violation. One person doesn't constitute a subcommittee. So the chair can certainly advise that one individual can work on a particular project and report back to the chair or to the entire public body as to what occurs. And certainly the conservative approach is if you feel as if a subcommittee has been created to post the meeting and comply with the open meeting law. So something to be aware of because we are seeing an uptick in that particular question. Another question that comes up a lot is, will a committee created by a particular, the town administrator or the superintendent, is that subject to the open meeting law? And it's going to depend on the fact and circumstances, but generally the answer would be no, if they're reporting to an officer that has sole jurisdiction over a decision. So the other thing that comes up a lot is, well, it's not a subcommittee, it's a working group or a task force or something named differently. And the name doesn't really matter. It's really how that group was created and what they're really going to do. Any questions on that? Okay. So I'm going to give some tips to stay out of trouble, which I call them the frequent flyer questions that we often see. If a public body member is attending a meeting of another body or a social event, you certainly want to, avoid creating the appearance that you're discussing municipal business. So what does this mean? All of you are probably very involved in the town, involved in community events, see each other, certainly are all committed to town government. And you just want to avoid the appearance if you're at a barbecue, a parade, a community event, a retirement party, that there's any deliberation outside of a properly posted meeting. Over the years, I've seen many complaints where people say, well, these 3 members must have been talking about this particular project because we saw them in the corner and they were talking. Well, they could have been talking about the weather or the holidays or their families, but you really want to try to avoid that appearance because it can create a question, so to speak. If you are going to meet with another public body, you might want to consider just posting the meeting to be held at the same place and time. We see that quite frequently. Maybe the planning board has to meet with the board. That's fine. Just put it together. Post it and do meeting minutes. For the land use board members that are out there tonight, if you're attending a site visit or a meeting of another public body, you might want to post a follow-up meeting if members anticipate that they want to discuss things amongst themselves. And then the big topic that comes up all of the time across the entire state that we're going to cover is avoiding email and other electronic communications to conduct public business. Email is specifically covered by the open meeting law, and we see complaints, many complaints every year. Get filed with the Attorney General's office regarding the use of email and text messages and social media by public body members. So we'll spend a little bit of time on that as well. Any questions as we are going forward? Okay, great. So let's start with agendas. I have referenced before that agendas have to include a detailed description of items to be discussed, and that is a very easier thing said than done. Sometimes agendas are very detailed, sometimes they're not. So I'll give you some best practices on that. Location of the posting, we know it has to be filed with the town clerk and posted in a manner that's very conspicuous. So if someone at home that just moved to town wants to go, they'll know where to go for the meeting. It's always a good idea not to use acronyms or abbreviations. And the reason for that is we may know certain phrases or certain project names, et cetera, but members of the public at home might not. And so it's probably best to spell those out if you can, just to be abundantly clear in terms of what's going to be discussed. You have to have the date and time of the posting on it. And that's really critical if there is an open meeting law complaint saying that the meeting wasn't posted properly. If a meeting's revised, which is allowed, you would want to state the date and time that it was originally posted, as well as the date and time of the revised posting. So those two things should really be on it to show it was originally posted on this date, but it was revised, you know, with that outside of that 48-hour window. So it was still timely. So we're going to go over regularly occurring items. And this is something that comes up a lot. So here's some best practices with respect to that particular topic. Regularly occurring items just need more detail, right? So it's fine to include general categories on a meeting notice or a meeting agenda, but really good idea to fill those in with some specifics if the chair knows. So some examples, new business or old business or a particular departmental report, you might want to put in new business and then some categories underneath. So members of the public will say, well, it's new business. I know the town's talking about this grant or this, you know, this roadway project. I really want to go to that meeting because that's of interest to me. Sort of the general catch-all categories. We know from determinations from the state, the AG's office, that you really want to be more specific than that, and they have found violations on those particular categories. So some practical considerations, and these come up all the time. A meeting may not be continued from one night to the next without properly posting it under the open meeting law. So an easy fix for that, if you know something particularly around town meeting season is going to stretch on for a couple nights, you'd want to post that meeting in advance for all of those nights. If you know you're going to review the warrant or there's particular topics that are going to require a more lengthy review. And the notice requirement, as many of you know that are with us tonight, under the open meeting law, that meeting posting doesn't substitute for any other requirements under 40A, for instance, or other statutes that require publication in the newspaper, for example, or notification to abutters. So I always like to flag that for everyone as well. Any questions as we continue on? Okay. Beth, you can let me know if you see any hands raised, if you don't mind.
Absolutely, I will let you know.
Thank you so much. Emergencies, we're heading into winter season and hopefully we'll have for your snow and ice budget, a quiet winter. But there are circumstances that will trigger an emergency. There are limited instances where we know that a public body can meet without the 48 hours notice. What we know is that poor planning itself doesn't equal an emergency. So you have a particular applicant that is like, well, I need this acted upon ASAP, and this needs to go on the meeting notice for tomorrow. There's a risk if you post that because it was poor planning instead of just putting it on to the next meeting. So generally natural disasters, public health matters, and public safety issues do qualify as emergencies. So before the past couple of years with COVID, it was really hurricanes, snowstorms, ice storms, blizzards, sewer issues. Those are really the types of categories that would trigger an emergency. But there are others as well, but it really rises above the level of just, I didn't know it should have been on the agenda. If you do have an emergency, and I hope you don't, practical recommendations, you're going to want to try to comply with the open meeting law to the extent you can. and really just talk about the emergency. So you don't want to say, town's response to blizzard of 2024, and also, town meeting consideration of warrant articles 1, 3, and 5. It really you want to limit it only to what you have to talk about because time is of the essence. You still have to take meetings of the minutes, and then you're going to review them and include them with your next regularly scheduled meeting. And you might want to just consider posting another meeting, or at your next regularly scheduled meeting, we had to meet on such and such a date. There was this emergency. We had no choice. This is what we talked about. This was the action that was taken. And therefore, the public is aware what took place. So I just wanted to quickly go over recordings. This is another area that I do get a lot of questions on, particularly in the past couple of years with an increase of so-called First Amendment auditors throughout the state. We know that the chair, just as I did tonight, though I'm not the chair, must make a public statement regarding audio or video recording if an attendee intends to inform someone. So, is anyone here recording? Someone says yes. Okay, does everyone here, this person is going to record the meeting, so everyone's on notice that they're being recorded. So individuals, members of the public, or other individuals who attend a meeting should really inform the chair if they want to record, and the chair must make the required announcement. This used to be an issue back when I first started doing trainings, but technology has certainly gotten a lot smaller. We used to have tripods and video cameras and those huge machines with VCR tapes. Now everyone has phones or recording devices. But regardless of that, obviously we don't want a hazard, and we don't want a phone in someone's face. And so the chair can reasonably record the placement and operation of the equipment. If there's any questions on that, let me know. So I want to shift gears, and we always say this is one of the more emerging issues in open meeting law over the past couple of years. The state has done trainings and issued guidance on this. Certainly our office has as well. There's always a significant amount of determinations that come out from the Attorney General's office on use of email and other electronic communications by public body members. And there are public records implications as well. So we'll touch on that a little bit. But what do we know? We know that email is specifically addressed in the open meeting law, and that it's often the reason for a violation. We all use a ton of technology. We're using it here tonight. Technology is an amazing tool. Unfortunately, technology doesn't coincide well with the open meeting law. The open meeting law, if we go back to the first and second slide, requires that public bodies meet in an open and transparent way so members of the public can see what's happening in real time. And so a quorum of a public body cannot use emails to share feelings, ideas, or beliefs or concerns, whether serially or in a single email, regarding any board business, and cannot use a staff member or a board member to avoid that requirement. It's a pretty clear rule in terms of using email to do a send all or reply all, or certainly communicating opinions or beliefs. I've included here some practical approaches to avoid violations. And while it's not always convenient, it's certainly the best practice, in my opinion. You want to beware of replying all on emails. So if an email goes out, can the board or can the commission or can we meet on, next Tuesday at 6 o'clock? Is that a good time? That is fine. People can respond back. Yes, that works for me individually, not reply all. But you really can't reply all and say, yes, that works for me, and I hope we get to talk about X, Y, and Z, because I think that would be great for the town. And I really think it would be a good opportunity, because then you're sharing opinions and beliefs. And a lot of the times when I see this, people are doing the best they can, and they're really trying to be efficient. However, we see hundreds of complaints about this every single year. So it's certainly worth really thinking about how email is used. Limiting email to scheduling purposes and avoid using email to undertake town business is really important. Public records requests often reveal how public body members use email, and then that will trigger an open meeting law complaint. You always want to assume that email, which is subject to the public records law, regardless of whether it's sent from a town email account or a personal email account, can be forwarded to a third party or the media or someone, a resident in town, and be put on Facebook. So you really want to be prepared, just if you see it, that it's going to end up somewhere online these days. And certainly you don't want to ask other members for anyone to express their opinions or feelings or belief. You know, a lot of public bodies I work with, at the bottom of their email will say, please consider not replying all, or please be reminded of the open meeting law, something along those lines when the schedule or the agenda is sent out, just as a reminder. So some practical tips there as well that I hope are helpful. Any questions on that so far?
I have one question for you.
Sure.
So the Bellingham Select Board has a contact page.
Yep.
And an email will come into the entire board that will specifically, ask a question about a street. And I've responded in the past and included the board so that the board knows that the member of the community had their answer addressed. Is it wrong to do that?
So I think the best practice there would be to respond individually and include it with the correspondence in the next board package.
But if in that email saying I've responded, the rest of the board has been included so that they know your question has been answered.
I think you could respond to say, I'll take care of this particular question. But again, I think I always get concerned that someone else may inadvertently chime in or express another opinion or belief that then has gone to the entire board. And so the thought would be maybe you acknowledge, or someone can acknowledge that they're handling it on the town hall side, and then that can be put in the board's package for the next meeting, so that there's no inadvertent deliberation outside of a meeting. That would be my recommended practice.
Okay, thank you.
Thank you very much for the question. Good question. I think I see a hand up from Stephen.
Hi, good evening. Thank you.
Thank you.
A question regarding quorums. If the bylaw is a 7-member quorum, 7-member board, and 2 seats are vacant, what is the quorum number?
4.
I'm sorry?
Is it an elected or an appointed board?
Appointed.
So it would be 4. The quorum is the entire complement of the public body.
Thank you.
Good question. Thank you. Anything else? Okay.
Yeah, would it be better using email to send it out as a BCC so that nobody can respond all?
Good question. So that is something that a lot of public bodies that I work with do also do. So there would be a BCC feature. I guess it goes back to the general principle that if one member is sharing an opinion or belief, regardless of whether it's a CC or a BCC, those other members have seen that member's opinion in an email versus in a open meeting. So really what the open meeting law says is that that can't take place at all. And so I usually see, for instance, if there's materials being sent out, right, by a staff member or a particular clerk for a public body, it'll maybe go to the chair with the BCC to the other members and say, please be advised of the open meeting law requirements, so that everyone isn't responding to all. but it really is limited to scheduling purposes or distribution of materials in advance of a meeting. Does that answer your question?
Yep, thank you.
Thank you. Okay, so we're going to move into we email, and now we'll do texting and social media, which kind of go hand in hand a little bit. Texting is something we see a little bit more than social media, but I always like to cover this as well. What the Attorney General's office has said for years is that texting and social media are also subject to the open meeting law. And we go back to that same principle that can't be communications, either before, during, or after a meeting outside of what the public can hear at the same time, in real time, essentially. And so texting and social media are subject to it. That also includes instant messaging, blogging, or Facebook, Snapchat, and Twitter. I've included here some practical approaches to avoid violations. I mean, frankly, texting is quite risky. We know from both the Supervisor of Public Records and the Attorney General's office and new guidance that was put out by the Inspector General's office that even if you're using a personal cell phone or personal device, if you're using that for town business or any business of the town based on your role as a town employee or a town board member, that those messages or those communications are subject to the public records law. And so that question I get a lot. It was on my personal device, or it wasn't on my work, it was on my work email. It doesn't matter if it's related to town business, it is subject to the public records law. And so some practical advice here is really to avoid using texting both before, during, and after a meeting. I know technology is very efficient, but it's the same idea of the example I used of seeing people in the hallway talking. It's the same thing if people see people texting. It often will trigger either a public records request or an open meeting law complaint. If you do get a text from a resident, you may want to just not respond and don't direct comments to other members of a public body. Certainly be thoughtful about the manner that comments are made, and consider using a separate account if you are elected for campaign purposes or following an election, and that just keeps things separate. I would say the same if you don't have a town email account. Maybe you have a separate personal email account for just town emails that you've sent on a Gmail or a Verizon account, for example. And so just some practical tips there. Remember that if you are, for instance, a licensing board or licensing authority or a land use board, remember that applicants have due process rights. And so if you're a board member that's involved in making a decision on a license, a permit, or an application, really only discuss those matters at the hearing. We often see both public records requests, but also if litigation is filed as part of discovery, requests now for social media posts or for text messages as part of that. So just be really mindful of how electronic communications are made. Any questions on that?
I have a quick one. So
Sure.
if a member of the public is interested, for example, joining your commission or board and sends you an email inquiring to know more about what the commission is about, could you tell me all about it? You're allowed to communicate one-on-one with that person, describe it. You're not discussing any business or anything. There's no limitations on that, is there?
That's completely fine. Yes.
Okay.
You are allowed to communicate with members of the public. What would trigger it is if that email then gets forwarded to the entire rest of the public body, or forwarded to one member who then forwards it to another and then forwards it to a third member or fourth member, depending on the size of the public body. So one-on-one is completely fine. I understand you all have constituencies and questions and are very involved in the community, and that is completely fine. It's more if there's a substantive matter that is before the board, you don't want to be texting. It comes back to the quorum or serial that turns into a quorum on a particular issue, but that's completely fine in my opinion.
Okay, thanks.
Thank you. Good question. So there was a case, and we're going to talk about it in a little bit, and many of you may have heard about it, that was decided by the Supreme Judicial Court this year that talked about public comment periods. And we'll go over it, but I wanted to just provide some guidance. Interestingly enough, the open meeting law does not mandate or require that a particular person, so any member of the public, be allowed to speak at a meeting. Most public bodies that we work with have a public comment period, and some are required by bylaw or charter. But the open meeting law itself does not require that public bodies require public participation at a meeting. Hearings are different. But the open meeting law allows the chair to exercise his or her sole discretion as to who may speak and for how long. And so some public comment periods are 15 minutes, some are 10 minutes, and we'll talk about some, we call them content neutral restrictions, about, really making sure you're able to conduct your public business while also hearing from members of the public. What we know is not allowed, and this has been the case for many years, but it was really confirmed by the court in this Barron case that we'll talk about, is allowing the public to speak. If you allow a public comment period, you can't then restrict someone's speech based on what they're saying. And so there have been a long line of cases for many years where, for instance, a member of the public that was very favorable to the town would get, for instance, 10 minutes, and someone that was critical may get less time. Can't do that. You also can't restrict it based on, someone saying it's not related to this topic, you don't get enough time. So really restricting it based on the message of that particular person is not allowed. It raises constitutional considerations, but you can determine the time in which public comment is made, beginning, middle, end of the meeting. And again, this is for public meetings, not public hearings, but you can decide when it is, how long, whether or not it's going to be allowed, and for how long can each person speak in a very content neutral way. Any questions on that? We're going to go into it in more detail, but I just want to give an overview. So these are some of the factors I had just mentioned. Whether or not to allow public participation is a policy decision. It does have these significant implications. When will it occur? Just mentioned that. How long will it be? How long will each person speak? And whether or not an individual will be allowed to speak once or twice. So some important questions to think about on public comment periods. And given the significant increase in questions in this area, here's a little bit of a snapshot in terms of items to consider. If you are a public body member that is thinking about public comment, or a public body member thinking about public comment policies or practices, you want to consider avoiding debate with individuals because it's not posted under the open meeting law. So it's generally not something that's on the agenda. You want to avoid responding to a comment if the board hasn't had the opportunity to discuss it, or if it's controversial. And it's okay to, we all have a tendency to be helpful and want to try to, have clarity or finish, provide answers, but it's okay to leave a matter raised during public speak unresolved. That's fine. And consider not engaging and placing it on an upcoming agenda if there is public interest for which formal notice is posted under the open meeting law. And so if it's a matter of a lot of interest to members of the community and the town has an interest in this topic, you can acknowledge it, say, I'm happy you're bringing that to our attention. We'll consider putting it on an upcoming agenda. Thereby other people can attend the meeting and provide additional feedback, and it gives the board members some additional time to review the question as well individually. Mike, I see your hand up.
Yeah, thanks. So does this have to be stated by the chair at the beginning of each meeting? I'm going to allow 15 minutes at the end of the meeting for public comment, not before that. And then the next meeting, if it's going to be a busier agenda and I don't want to allow as much time, I could say, we're going to do 5 minutes in the beginning for questions, but not at the end. And can it vary?
So good question. If you're considering public comment, it should be listed on the agenda. at the time that you think you can get to it. And so a lot of public bodies or communities have a public comment policy that says at the beginning of the board meeting, if time allows, we will allow 15 minutes of comment. And then it's listed as an agenda item that says public comment 7 to 7:15. So it takes some of the pressure off the chair in that case. But it should really be listed on the agenda if it's something that's going to be reviewed. Does that answer your question?
Slightly, one slight variation of that. So that's different, the public comments, than someone from the public being invited for one of the hearing items, one of the issues on the agenda, is there any questions from anybody that's a butters on the particular issue? That's not a public comment. That's questions and answers that come out during the course of the hearings, correct?
Exactly. So a public hearing, yes, abutters will come out, they'll give their perspective, neighborhood businesses, for any sort of permit, license, variance, anything that requires a hearing, right? There's notification that goes out and I don't even say public comment, feedback or public hearing comment is allowed during that. That does not need to be separately listed on the agenda. Good question.
Thank you.
Thank you.
Now,
Yes.
Mike, does that answer your question about the difference between public meeting and public hearing?
So basically, the difference between a ship and a boat, you can put a boat on a ship, but you can't put a ship on a boat. The hearings exist within a meeting, but are not separate. You don't have a public hearing just as a hearing by itself. Is that correct?
That's correct. So the open meeting law, you post your meeting, you have your meeting, and within that meeting, there is a public hearing. Correct. So a public hearing is usually on licenses, permits, or anything that requires, an application, something that's to be considered, that is usually listed as part of other business that the public body is conducting.
Good. Yes,
And as part of that topic during the public hearing, abutters or other members of the public can provide the board or the commission with information that they want to provide, or any evidence or documents, etc., as part of that public hearing within a public meeting. Good question. Thank you. So, I feel like I'm saying a lot of no, like, no, don't do this, no, don't do this, no, do this. But, I think this is, again, to really provide everyone with an overview so it makes your jobs easier, hopefully, is the goal. And we know that there are times, everyone's busy, your boards are busy, the town is busy, there's always a lot going on, that something isn't anticipated. Like it wasn't on someone's radar, it wasn't on the agenda. And so if it is truly unanticipated, something that just came to the chair's attention, it can be posted. The agenda can be updated. The best practice is to update it as soon as you can and show the date and time of that update, grant application regarding police department and put it on the agenda. Matters not reasonably anticipated by the chair may be discussed and acted upon. So it is an option if it's truly unanticipated. The Attorney General's office for years has recommended that unless a matter requires immediate action, that it really should be put off and included in a posting with the 48 hours notice. But if time is of the essence and it's not reasonably anticipated, there may be a way to do it. But you should post the meeting, update your meeting agenda to make sure members of the public know it's on there. Okay, so we're gonna move in. Oh, Steve, you had a question?
Yes, on the last item, if regarding the meetings, if a member of the public shows up randomly to a board and to raise not necessarily an issue, but ask questions to get board feedback or advice as to how they should proceed on something, is that an item that really should be put on the agenda?
No, if that's something that's raised during public comment, if I'm understanding your question right, if member of the public comes to a meeting and says, how can I how can I do this? How can I apply for this? I don't, I need some guidance here. One option would be, oh, feel free to call, town hall tomorrow and someone will walk you through it. I think that would not be reasonably anticipated that someone would show up. But you certainly won't want to have a long deliberation. I think you kind of deal with members of the member of the public, answer the question, and then move on if it can't be referred to town hall personnel.
If the question transitioned from a procedural, how do I do something question to I'm having a specific issue, what do you recommend? Should that be listed on the next meeting agenda?
I think the best practice, particularly if it's a matter that might be more controversial or maybe of interest to the town, the community in town, more than just this one individual, the best practice would be to put it on for a future agenda.
Thank you.
Thank you. Good question.
Janelle,
Yes,
Arian has a question also.
Grace. Thank you. Hi, Ariane.
Hi, thank you. I'm just kind of wondering, when a matter that's not reasonably anticipated happens during a meeting, do we go back and edit the agenda that we had, or post like a final agenda that has that added to the bottom, or can we just put it in our minutes?
So if it's something that's brought up mid-meeting, that wouldn't likely be anticipated. The question really comes down to how the public body is going to deal with that, which ties into our last question. So if it's something that is brought up mid-meeting, what about this? Or, is the board aware of this? Or what is the town doing about this? And I don't know if that's the focus of your question. I think there can be a short answer, but it really should then be posted at a future meeting. We really don't want to get in a position where there's a deliberation on something, even if it's not anticipated, that the public body members might not be prepared for, or certainly may be of interest to the greater community. But you don't have to amend the agenda mid-meeting for that.
Okay, thank you.
Thank you. Good question. Any other questions? Feel free to interrupt me. Okay. These are all good questions. Thank you. I appreciate them. So we're going to go through meeting minutes. In the past couple of years, there's been a huge uptick in requests under the public records law and the open meeting law for meeting minutes. So wanted to just go over what needs to be in the meeting minutes and the approval process, just to make sure everyone had the most up-to-date information. We know that meeting minutes have to have the date, time, the place of the meeting, and members present and absent. Meeting minutes do not need to be a transcript. They do not need to be a verbatim account of what the public business was for a particular evening. I know that different public bodies have different practices for meeting minutes, and there's no right answer per se. But we know that meeting minutes don't have to be a transcript, but they also can't be so sparse that members of the public won't know what was discussed. And again, we use my sort of example of someone moved to town and they're like, well, what is the planning board doing? What is the ZBA doing? And they pick up the meeting minutes and they should understand generally what occurred at the meeting, the topics that were discussed, and the substance, any votes taken. So we know that it has to have the decisions made, the actions taken, and the votes that were recorded. No secret ballots are permitted. The meeting minutes should also include, as a best practice, the documents that were used at the meeting. They don't need to be physically attached to the meeting minutes. I know sometimes there's large plans or other information that may, for instance, not be amenable to storing together. But that being said, they should reference, an application. It should reference a plan or a map, or another document, maybe an expert report that's reviewed. Anything that's reviewed should be just referenced in the meeting minutes. Open session meeting minutes have to be created and approved in a timely manner. And the current open meeting law regulations say that that's within the next 3 meetings or 30 days, whichever is later. So obviously that time frame is going to change based on how often your public body meets. Is it quarterly? or is it, every other week or every week? And I know there's some public bodies that meet a lot leading up to town meeting. So certainly try to be mindful of this time frame that the Attorney General's office has put out. The minutes of open meetings are public as of the moment of their creation, regardless of whether they've been approved. So draft meeting minutes are still public records, even if they haven't formally been approved by the public body. And oftentimes the request comes in as either a public records request or a request under the open meeting law, and the meeting minutes generally have to be provided within 10 calendar days. It's 10 business days if it's a public records request, but it's 10 calendar days if it is a request under the open meeting law. Any questions? Oh, Ariane? Yep.
Hi, sorry, one more question based on
No, of
that.
course.
So if our draft minutes are also public record, do we have to provide all the drafts and the final version when they request those records?
No, once they're approved, I muted myself. Once they're approved, it's just the final meeting minutes that would be provided.
Okay, thanks.
Thank you. Good question. So executive session meeting minutes are obviously different. Executive session topics are sensitive and confidential, and so they're not generally made public right away, given the topic that's at issue. And some may remain confidential for years, depending on what was discussed in executive session. Executive session meeting minutes under the open meeting law can be withheld until the purpose of the exemption has been met. So if there's litigation, for instance, and a public body meets under purpose 3, those meeting minutes are going to be confidential until that litigation is fully resolved. And then even still, there may be some information there that has to be redacted or withheld if it's protected by the attorney-client privilege, for example, or has sensitive information, personnel information, medical information, other more details of a highly personal nature that might have to be redacted or withheld even after the meeting minutes are released. The chair of a public body should review best practice, review executive session meeting minutes periodically, and make a recommendation to the public body to see if they can be released. This is an undertaking, and understandably, but really the Attorney General's office says this should be done about quarterly, where essentially you would want to pull out your executive session meeting minutes that haven't been reviewed for a while and put them in piles and say, okay, this one looks like this purpose has expired. This one looks like it hasn't, and really make those recommendations. We do deal with requests for executive session minutes, so it's a good idea to do it if you have the time during a particular meeting. You want to approve your executive session meeting minutes in executive session, and you want to review them for whether or not they can be released in executive session. You do not want to approve executive session meeting minutes in open session in case there's changes. You don't want to disclose what's confidential. You also don't want to review them for release in open session. So executive session until they're actually released. Any questions on that? Great. So executive sessions, sure, some public bodies here meet more than others in executive session. I've provided Dennis and Beth some guidance documents on that we'll distribute after the training tonight. There's a checklist in there that's particularly helpful from the Attorney General's office about convening an executive session. It's just a handy guide, I think, to have. But we know that you always need an open session meeting, even if you're just going to go right into executive session. So it'll say, meeting of the planning board, 6 o'clock, and then right underneath executive session, litigation case, purpose 3, list the name of the case. Announce the purpose of the executive session without compromising, obviously, any confidentiality. And all votes have to be recorded on roll call for an executive session. And then alert members of the public whether or not the meeting is going to end from there. For instance, if that's the only topic, or if the executive session is first at the meeting, And then you're going to come back and do your open session business. You might want to say, we expect to be about 15 minutes or a half an hour. We'll come in after that and do our open session business. So that's a good practice pointer there. Maintain exhibits and documents, close to the meeting minutes. Obviously, they're likely confidential and sensitive. And so you want to make sure they're maintained in a confidential manner. Really only discuss the matters cited and not matters that could be reviewed in open session. And I had mentioned that particular statute, chapter 38, which is the open meeting law, section 21, and that lists all the different executive session topics, but we've provided a handout for that as well that we can distribute afterwards.
Janelle, you had on there that everything has to be by a roll call.
That's correct. Yep.
Just to re-emphasize that it needs to be by roll call, not just aye or nay.
Yes. And so it's going through, essentially almost attendance of the public body members and then individual members and how they will vote on that particular issue.
Thank you.
Thank you. Some practical considerations or issues here. If an executive session is anticipated, you do have to list it with appropriate detail on the meeting notice. So I do get this question frequently, mid-meeting, can we decide to go into an executive session? The best practice would be not to do that. You really want to list it if it's anticipated on the meeting notice itself. I've seen individuals kind of question that practice in the past, unless it's truly an emergency. And for certain purposes, you do want to make the declaration that meeting in executive session would compromise the town's position. And we have a guidance document that we'll distribute afterwards that goes through that in a lot of detail. I just want to flag a couple of particular items that we get a lot of questions on. If you're speaking about a particular under purpose 2 or purpose 3, a position or an employment matter, a collective bargaining matter, you really want to list the particular unit, the bargaining unit, or the position at issue. So just some thoughts on that. In addition, if you have litigation, best practice would be to list the case that's being discussed, unless listing it would compromise the town's position in that case. And the same would be for a real estate acquisition as well. You really want to try to list the property address, again, unless doing so would compromise the town's bargaining position on that matter. Enforcement, I always include this here. It's certainly not to, make anyone nervous or, raise any concerns. It's really just more for informational purposes. So you all know if you get a complaint or have to deal with this, this is the process that would be in play. Oh, did you have a question, Vinny?
No, I'm all set.
Oh, okay, thanks. I thought I saw a hand. So essentially, step 1 is that a written complaint is filed with the public body, and the time frame of which that should be filed is it within 30 days that the violation became known to the individual. And there's a form, and the complaint has to be listed on that particular form. The public body must forward to the complainant for the complaint in a response within 14 business days, unless there's an extension of its response to the allegations in the complaint. And then from there, if the individual is satisfied, nothing further happens, and they consider the individual, the complainant considers the complaint resolved. If they're not satisfied, essentially, they would file a request with the Division of Open Government for further review of the complaint and a determination as to whether or not the open meeting law has been violated. There are a wide range of options that the state has if there is an open meeting law complaint determination. Sometimes it's training, sometimes it's review with the office in terms of best practices, release of meeting minutes. If there was if a public body met in executive session and they shouldn't have, a release of a portion of the meeting minutes. There is a wide range of different options available to the Attorney General's office. So I've listed all of those there, and if there's any specific questions, you can certainly reach out to me after the training. So here's and I apologize, I know there's a lot into the top bubble here, but wanted to include a couple of these notable court decisions so everyone had them. The first case is the Barron case, which involved the town of Southborough, that was decided this year, that talked about the select board policy, public comment policy. For any public body members out there, I would encourage you to read our guidance, which we will circulate to this group after the training regarding the facts of the case and the particular court's holding in that case. And we always include it in our open meeting law training because while it didn't examine the open meeting law, the court essentially premised its conclusions or its findings on the fact that the board allowed public comment on its meeting agenda and decided that once that public comment was included as an item for discussion during the meeting, that those constitutional First Amendment free speech considerations that I had mentioned before applied in the board's efforts to regulate those public comment. And so the court really went through the analysis of the constitutional considerations regarding a public comment period. State law, as I had mentioned, doesn't require the town to provide a public comment period, but charters and special acts sometimes do. And so we certainly recommend that significant care and attention be provided to ensure that if there is regulation of any public comment period, it's limited to those, we call them reasonable time, place, and manner restrictions. The time period it's allowed, when it's going to be during the meeting, will individuals be allowed to speak once or twice, rather than mandating, and this is the court's language, civility or other content-based restrictions. Absent criminal conduct or other sort of heightened concerns about public safety, after this decision is quite difficult to regulate the speech that's made during a public comment period. So I've included that case there. That's really the big case for this year with respect to public comment periods. There was a prior case involving the town of Natick School Committee that the ACLU was involved in that also talked about public comment during a school committee meeting, where the court held that the committee improperly limited comments made by members of the public, which were critical of the committee, in violation of those individuals' free speech rights. And the takeaway is very similar, where a public body allows public comment or an open forum period, then any discussion has to be limited to the public body's interest and can't be regulated based on the content of what someone is saying. So I've included that case as well. If anyone wants copies of these cases, I'm happy to provide them, but we do have an overview that I know Beth and Dennis are going to share afterwards. The town of Swansea case dealt with the sufficiency of meeting notices, and basically evaluated available bulletin board space, which we all know is precious space in town hall, to determine whether or not a meeting notice was sufficiently detailed. And then the Bolter case involved the town of Wayland, and that talked about employee evaluation process by public bodies and talked about how that really should occur in open session. And the Division of Open Government has updated its guidance following that decision back in 2018. Any questions on any of those, Mike?
Yeah, in the very first one, the last sentence that you talked about, basically the board should limit itself to the time, place, and manner restrictions. In the past, if a committee has declared in the beginning of a meeting, for example, especially during the COVID period when we're hybrid or Zoom meeting format, that if someone did not identify themselves prior to speaking, they would not be given permission to do so. Is that legal to say that? That's a manner restriction. If you don't identify yourself, you're anonymous, phone, IP phone number or something like that, and that's it.
That's a good question. That question has come up a lot since the Barron decision was decided this year. I think it would be very difficult for public bodies to require that after the Barron decision. While you can certainly encourage individuals to identify themselves so that the public body can know kind of where they are, what they're dealing with, I think encouraging is different than requiring. And I think in light of this decision, the best practice would be to not require individuals to identify themselves.
So if someone came on and started just yelling and shouting and so forth, came online, you can mute them and not permit them to verbalize and disrupt the meeting, correct?
Sure. So obviously Zoom bombing, anything illegal is not allowed. We know that. With respect to other comments, if it's harassing, it would have to really kind of cross the line, in my opinion, to criminal harassment, almost like threatening, something that I hope never occurs at any of your meetings, but I think unfortunately we've all read about. If it's disorderly, the court basically analyzed it in terms of, is someone standing in front of someone? Is someone pushing someone out of the way to speak during a public comment policy? There isn't really the same analogy for a Zoom meeting, but I think constantly interrupting someone or not adhering to the chair's comments about being orderly, I think would be a closer basis. What the court said is basically the chair is entitled to maintain order during the meeting, right? And what that means is you can't interrupt, you can't obstruct other speakers. That is not, protected speech essentially, but you can't just, if someone comes in and they're yelling about town government, or they're yelling about a board, or they're claiming allegations, that I think after the Barron decision is going to be permissible or protected speech.
Yeah, thanks.
Thank you. Good question.
Ariane had a question, but I don't see her hand anymore.
Oh, do you
Yeah,
want
my question was answered. Thanks.
Okay, no problem. I mean, obviously, I think the line has moved. The court really clarified how broad the scope is of these constitutional protections during the public comment period. And the guidance document that will circulate after this training, when you read it, it's not very long, it's a page or so, but when you read the facts, you'll see in terms of how the court analyzed that particular issue. But I think orderliness, anything that creates a disorderly atmosphere during the meeting, but it really just can't be based on the message of the speaker, is the bottom line. Mike?
Yeah, one and follow up then.
Sure.
Is it a requirement that at any given meeting, public meeting, that there is an understanding that there is a open public comment period, even if it's not stated by the board chair, or is it the opposite? If, in other words, if I as a chair don't say there's going to be a public comment section, then there is none, and therefore this public comment concern goes away somewhat. It would just be during the hearings that they're actually speaking.
So yes, so there is no requirement for public comment under the open meeting law. There is a requirement for public testimony during public hearings, which are different. Some communities have charter provisions or special acts that require public comment period. So would just want to confirm that. But that being said, I think there have been overtures by some groups after the Barron decision to say, well, communities shouldn't restrict public comment or remove public comment off their meeting agendas, because it's really an avenue for residents to voice their concerns. That being said, under the open meeting law, in my opinion, it is not required. Public comment is not required. But I think this is an unscientific analysis. I think most public bodies still allow it, but they have put in or considered policies to have very clear guidance for chairs to say, it'll be this period of time, everyone gets, it'll be 10 or 15 minutes at the beginning of a meeting or at the end of a meeting. And each speaker has 3 minutes to speak, and each speaker will be allowed to speak once. So I think some communities have moved in that direction to, one, advise members of the public for clarity as to what the public comment policy is, and two, to make it a little bit easier for public body members, including chairs, to implement, so that everyone's on the same page after this Barron decision as to what is allowed and not allowed based on those time, place, and manner restrictions.
Thanks.
Thank you. Good questions. So we're ending sort of we're towards the end of our presentation today, but I wanted to just provide an overview of the current state of the open meeting law. As many of you probably know from other guidance that has been sent out the past couple months, or really since March, time flies, it's almost the new year. Pandemic era changes that were put in place in 2020 are still in place till March 31st, 2025. So on March 29th, the governor signed into law the supplemental budget that extended those temporary provisions pertaining to the open meeting law, allowing, for instance, remote participation for public body members or members of the public to meet remotely until March 31st, 2025. So that is still in place until March 31st, 2025. I will just flag for everyone here tonight that there's many pending bills at this time at the State House with the legislature regarding the open meeting law and permanent measures. There were a variety of hearings this summer to put into, to make some of these changes permanent or to make certain adjustments for hybrid meetings. If anyone wants any information on that, I'm happy to supply it, but none of them have really moved forward yet. But we know that this is in place until March 31st, 2025. What is authorized, so we know under this order, instead of holding meetings in a public place, a public body can provide adequate alternative means of public access, and public body members can also participate in meetings remotely. Meetings do not need to be held remotely. The changes are completely optional. Meetings may still be conducted in person, so the option is completely in person, completely remote, or we call hybrid, which is a variation of the two. Adequate alternative access, and many of you probably know this since 2020, but it's always good because there's determinations that still get issued on this topic quite frequently. A public body must provide essentially members of the public real-time access. So someone sitting at home or on their phone has to be able to watch what's happening in essentially real time. And what we know is a lag of about 20 seconds is acceptable, and that allows the tech to work. If there is a technical problem that prevents the meeting from being accessible, the meeting should be paused or rescheduled depending on how severe the issue is. Continuing a meeting and posting a recording, even immediately afterwards, doesn't cure the violation. I've included 2 2021 decisions from the Attorney General's office on that topic. Zoom, like we're here tonight, is the typical alternative means, but it's not required. And anything that allows members of the public to follow along in real time is fine. Some additional considerations if you are going to hold a remote meeting. Again, make the recording announcement if the meeting's being recorded. All votes would need to be taken with a roll call vote, just as we had mentioned with an executive session that Beth and I were talking about earlier. Remote meetings you have to introduce yourselves or be introduced at the start of the meeting so members of the public can know who's who. And camera should be on if there is a camera. If a member is participating by phone and they don't have a camera, that's fine. But if possible, the camera should be on. This is one that comes up from time to time, but I always like to include it in my training. When holding an executive session remotely, the member participating, the best practice is that they should state that there's no one else that can hear the discussion, given the confidentiality of the executive session. So sometimes you'll hear people say, I'm in this room by myself, I have headphones on, no one else can hear me. It doesn't, there's not a script or anything. It's just really an acknowledgement that no one else can hear the confidential discussion. Hybrid meetings, many public bodies are still meeting in a hybrid format across the state. A public body can meet in person, but require members of the public to watch a live stream, and direct participants on an agenda matter may still attend in person, even if members of the public are remote. So if there's a particular license that's being reviewed or a particular project, maybe the members are there in person and the applicant and maybe their attorney or their consultant is there and everyone else is remote. We know that's fine. A member may attend remotely if even other members attend in person, but if the live access stops, the meeting must stop. A couple of other considerations. Be careful not to deliberate. So we want to always be careful of what I call the hot mic issue. You know, if the meeting's being recorded, or you're waiting for a meeting to start, whether in person or remotely, or at the alternative at the end of the meeting, you want to be careful there's no deliberations that occur before or after the meeting, because certainly that falls within the open meeting law. And be careful not to do that over text or email as well. The public body can resume the meeting if the tech problem is resolved and everyone can see it in real time. And the public essentially must be able to hear and follow the meeting from their remote location. One person's tech problems isn't the public body's problem. Like if someone's at home and they're like, my computer's not working, my internet connection's down, my phone died, that is not the town's problem. But if generally there's a disconnect, I'm tech savvy, but not that tech savvy, that's a bigger issue. So that's really when you want to consider postponing the meeting. Any questions?
Janelle,
Yes.
I have a question. We have cable 8
Yep.
who records our meetings, plus we do Zoom. What if one of them goes down, not the other?
So is the meeting posted as an in-person meeting with the Zoom as a courtesy?
Yes, but we also have the cable 8.
Yeah, so that's fine. If the meeting's posted as an good question. If the meeting is posted as an in-person meeting, meaning members of the public can attend in person at town hall, wherever the meeting is, and the Zoom link goes down, that's really done as a courtesy, I would imagine. And so the meeting can still go on.
Thank you.
Mike?
So if an applicant who is in the process of being heard has a technical problem and only their problem, their audio goes out and we can hear them, but they can't hear us or something like that, is the appropriate thing to stop hearing that particular item until another meeting, or it can be resolved, and then it's acceptable to continue with the rest of the meeting and other hearings?
That's fine.
Okay.
I would recommend that practice. Yep, because you want to make sure the applicant, because of due process rights, can continue with their presentation.
Okay, thanks.
Good question. Meetings may be held in person if the meeting's open to the public. If there are restrictions put back in place, let's hope they're not, then you have to have it in an accessible location, and you have to accommodate an individual's request if they do need an accommodation. Ariane had a question?
Yeah, I see on there it said no limits because of COVID restrictions for the open meeting, but what about like fire code?
Good question. Yes. So as we all recall, previously there were, gathering restrictions. Those have been lifted at this time. Fire code is still a consideration. So the option would be to relocate the meeting if there are fire code issues. So if the meeting is in person and you expect a significant turnout for this particular meeting, the meeting can be moved to an alternative location that's bigger, that can accommodate everyone. And the members of the public, so sometimes it'll be a sign on the door that says meeting has been moved to this location. And then you maybe want to put it online and update the meeting agenda if you can as well.
Thank you.
Thank you. I appreciate everyone's time tonight and patience in going through the slides. Happy to answer any other questions that anyone has. I do want to just say that the slides and the materials that I had mentioned, there's, I think, 4 or 5 other handouts that I think would be good for everyone to have in their open meeting law binder or file. So we will distribute those after the training tonight. And certainly if there's any follow-up, I know it was a lot of material. If there's any follow-up questions, certainly always reach out. I'm happy to answer them. The open meeting law guide that the Attorney General's office puts out is also a really great resource for everyone to have. It was updated just recently, a couple of years ago, and really walks through things in a way that's, I think, very helpful to public body members and town employees. But certainly happy to answer anything else that anyone has tonight. And I appreciate all of your time this evening. And happy holidays to everyone.
Thank you, Janelle.
Thank you all. Thanks so much.
Thank you.
Thank you.
Thank you.
Thanks.
Have a-
Thank you.
Thank you very much. Nice seeing you all. Have a good night.
Thank you.
Thank you.
Good night, everyone.
Good night.
Hi, Joe.
Thank you.